You're 6 weeks out from your accident. The medical bills are stacking up, and those are at least the ones you can point to on paper. But your shoulder, it still catches every time you reach for something on a high shelf. You've not slept through a full night since the crash. You missed your kid's soccer game because you'd not sit in those bleachers that long. None of that comes with a price tag, and you are sitting there wondering how anyone is supposed to put a number on that pain. That is exactly what people mean when they say pain and suffering. And here's the thing, almost nobody knows walking in. There is no formula in New Mexico law that spits out that number. Insurance companies use their own internal methods to estimate it. And if your case does not settle, a jury sets it instead. I'm going to walk you through both of those, and then the specific concrete things that actually move that number, because it does move. And by the end, you will know the one thing that moves it more than anything else. And it costs you nothing to start today. So let me start with what pain and suffering actually is. In legal terms, it is what is called non-economic damages. Not your medical bills, not your lost wages. Those are economic damages, and they are relatively easy to add up. You have a receipt, a pay stub, a hard number. Pain and suffering covers the physical pain itself, the emotional toll, the disruption of your life. It is real. It's just harder to put a receipt on. And frankly, that is exactly why insurance companies love to fight about it. If they cannot dispute your medical bills because they were in black and white, they go after the pain and suffering number instead. That is where the real negotiation usually happens. So how do insurance companies actually get to that number? The most common approach is called the Multiplier Method. They take your total medical expenses, what is called your specials, and multiply that by a factor, usually somewhere between 1.5 and 5, depending on how severe your injuries are. Say your medical bills come to $20,000. A soft tissue injury that cleared up a few months might get a multiplier around, say, 1.5 to 2. A herniated disc with ongoing treatment and permanent restriction might get a 4 or 5. So that same $20,000 in bills could represent anywhere from $30,000 to $100,000 in pain and suffering value, depending entirely on the severity and permanence of what happened to you. That's a huge range, and is exactly why two people with nearly identical bills can walk away with wildly different settlements. But I want to be very clear about something. This multiplier is not a rule written in New Mexico statute. There is no law in the books in this state that tells an insurance company which number to use. It is an insurance company practice, a starting point that adjusters use internally, and is also a tool your attorney uses when negotiating. It is a tool, not law. And because it is just a negotiating tool, the number can move based on how strong your documentation is. I've had adjusters open with 1.5 on a case that honestly deserved a 3 or 4. Not because the law required a lowball, because that is the opening position. It is on you, your attorney, to bring the evidence that justifies moving it up. There's a second method that some adjusters use, especially when there's a defined recovery period. It's called the Per Diem Approach. And per diem is just a fancy way of saying per day. Instead of multiplying your bills, they assign a dollar value to each day you are in pain. From the day to the crash to the day you reach what is called maximum medical improvement, or sometimes MMI. That's the point where your doctor says you've recovered as much as you're going to. So at that point, you multiply the daily number by the number of days. And that is the value that they assert. Say the daily rate is $100 and you're in pain for 200 days before you leveled off. That's $20,000, separate from your medical bills. Now, this is a lot less common than the multiplier, but you will see it especially with clear injuries and a clean recovery timeline. A broken bone that heals in 4 months is a good candidate. A permanent injury that never fully resolved usually gets a value with the multiplier instead of that per diem argument, because there is no clean end date to count against. Here is what I actually want you to take from this. Neither of these methods is written into New Mexico law. There is no statute telling an adjuster which multiplier to use or what your daily rate should be. They are negotiating frameworks, which means that the number is not fixed. It moves based on what you can show. So let me tell you exactly what moves it. And that is the part that costs you nothing but attention. Consistent medical treatment. This is the single biggest factor, and it surprises people every time. If you go to the ER, then do not see a doctor again for 6 weeks, the insurance company is going to argue that you were not really hurt, or that whatever happened in that gap is what causing your pain now, not the crash. I've had clients tell me they stopped going because they felt a little better, or couldn't take the time off work, or honestly, just did not want to keep dealing with it. I recognize all of that, but every gap in your treatment becomes a talking point for the adjuster. And it is one of the easiest things to avoid if you simply know about it ahead of time. That right there is the one thing that moves your number more than anything else, and it is entirely in your hands. A pain journal. I tell almost every client to start one on day 1, and almost nobody does it without being told. A few times a week, write down what you're actually experiencing. Not still hurts. Be more specific. I couldn't lift my daughter today. I woke up at 3 a.m. because I could not find a position that was comfortable. Had to leave my shift early. That kind of specific, contemporaneous record is worth far more than trying to remember 6 months later how bad week 3 really was. Nobody remembers that accurately. And insurance companies know it. Documenting the impact on your daily life. This goes past the journal. A short written statement from your spouse, a coworker, someone who watched you struggle with things you used to do without thinking. Photos. If there is anything to photograph, the goal is to build a picture of your actual life, before and after, instead of just a stack of medical codes. A spouse who writes 2 honest paragraphs about the trips you canceled, the chores you can't do, The nights you can't get comfortable, that carries a real weight. And it's not about exaggerating. It's about making the invisible part of your injury visible to somebody who you've never met and will never will. Let me show you how this plays out with a real example. I once had 2 clients around the same time, both rear-ended, both with a herniated disc, confirmed on imaging, similar bills on paper. One kept every appointment, kept a pain journal, had her husband write a short statement about what changed at home. The other had a rough month, missed a couple follow-ups, and figured out they would tough it out rather than get back to physical therapy on a busy week. Now, every case is different, and I can never promise an outcome. But across the cases I've handled, when injuries look similar on paper and the settlements come out very different, the difference almost always traces back to the documentation, not the injury itself. Same injury on paper, different record. That is a number moving in real time. So here's a question worth asking yourself. If you were in the middle of treatment right now, have you missed an appointment because it felt like a hassle? That is worth going back and fixing before it becomes a talking point in your case. Drop a comment and let me know, because I hear that more than you think. And one more thing, juries in New Mexico are the ones who ultimately decide these cases if they do not settle. And jurors, they respond better to specifics, not generalities. I was in pain does not move anybody. I could not pick up my son for 4 months because of what that driver did does. That is the difference between a vague claim and a documented one. And it is true whether you're negotiating with an adjuster or standing in front of a jury. So here's the bottom line. Pain and suffering is real and is compensable, but nobody is handing you a number off a chart. Insurance companies use methods like the multiplier and the per diem as starting points, not fixed rules. And the actual number moves based on what you can show. Consistent treatment, a pain journal, real documentation of how your life actually changed. These are the things that turn a vague claim into a strong one. And every one of them is something that you can start today. If you're in the middle of a claim and you're not sure your documentation is where it needs to be, give me a call. It's free and you'll at least know exactly where you stand. I also have a video on why an attorney matters from day one, so go watch that next. And if you've missed a treatment appointment because it felt like a hassle, tell me in the comments. Hudson Injury Law, 505-416-4150. HudsonInjuryLaw.com. The consultation is free.